All right, class, welcome. In this video, we're exploring performance and excuses for non-performance in contract law. We'll be walking through key doctrines that help determine whether a party must perform or whether the law provides a valid excuse. So before we talk about excuses for not performing, we have to start with the basics. Was there even a valid contract? And you can remember the core elements with the mnemonic. Look for deals that everybody really trusts. That's legal capacity, formation, definiteness, terms, enforceability, reality of consent, and terms that are clear. So if there's no valid contract, then there's nothing to enforce. Now we ask, if there is a contract, does the party still have to perform? What if the other side breaches or subject matter is destroyed? So these questions lead us into the doctrines that either enforce performance or excuse it. So when one party breaches, the type of breach matters. A material breach is like painting a house pink instead of white. It goes to the heart of the deal and excuses the other party's performance. And with a minor breach, such as forgetting to paint a closet, that may still require performance, but it can lead to damages. Performance may also hinge on certain conditions. A condition precedent must happen before any duty arises. A condition subsequent ends the obligation. And concurrent conditions mean that both sides must perform simultaneously, like handing over cash while receiving goods. Sometimes conditions don't have to be met at all. Why? Well, if one party hinders performance, the conditions may be excused. Substantial performance can also satisfy implied conditions. And through waiver or estoppel, a party may lose the right to enforce a condition that they ignored or misled the other side about. Performance might also be excused by law. Impossibility, like the death of a key performer, or impracticability, like unexpected extreme hardship, can excuse duties. So can frustration of purpose. Offering to perform, known as tender, may also discharge duty. And again, a condition subsequent might cut off a party's obligation. Now let's go deeper into frustration of purpose. This applies when a contract's central reason collapses, even if the task is still technically possible. In a famous case, 𝐏𝐞𝐫 v. Henry, the king's canceled coronation parade meant that the rented viewing room no longer served its core purpose, and this excused the tenant. And sometimes parties just agree to change things. A rescission cancels the contract altogether, and a modification alters the terms. Note that under common law, this usually requires new consideration. And a novation brings in a new party to take over performance completely. A different kind of deal is accord and satisfaction. An accord is an agreement to accept different performance, say $500 instead of $1,000. When that new performance is completed, that's satisfaction. The original duty is discharged. So even if a party breached, the law sets time limits, and that's where the statute of limitations comes in. For example, if an oral contract has a 3-year limit, you can't sue after that, even if the other side clearly breached. So to wrap up, we've looked at breach types, conditions, doctrines like frustration of purpose and impossibility, and how later agreements or legal limits can excuse performance. Now remember, contract law isn't just about making deals. It's also about when and how deals can be undone.